Welcome everyone. I hope this video finds you safe and healthy and in good spirits, considering the extraordinary times that we're living in right now. Um, so this video is going to be one of several, just a series of short videos that are designed to revisit some of the concepts we learned earlier in the semester when we first started talking about persuasive writing. Just so you can refresh your memory and get back into the swing of things. So we're going to start with the argument section, and we're gonna focus first on organizing the argument. So here we go. So you need to think about your brief's argument as your framework, the structure around which you build your oral argument. The judges who are going to be deciding the appeal that you're writing the briefs about, if this were a real appeal. They need a clear path to follow in your briefs argument, because without that clear path, they're going to get lost. They're not going to be able to find their way to your conclusions. So I guess I'm mixing metaphors here by calling it a path and a framework. But regardless of how you think about it, it is the skeleton upon which you're going to build your argument. So we're going to look at some pointers here on how to put together that framework, just reviewing a process we've talked about numerous times. So step number one is that you need to figure out what the main rule of law is. And when I say main rule of law, I mean the rule of law, the basic rule of law that applies to resolve the main issue that's present in the appeal that you're going to argue in writing. Okay? Um, and the reason this is important is that the large-scale structure of your argument in a brief is always based on the main rule of law that you're applying to resolve that issue. So you got to find and understand the rule structure. Now keep in mind that you may have to synthesize this rule, because the whole rule may not be present in a single authority, such as a precedent case. Sometimes it is, sometimes it isn't. But often it's the case that parts of the rule are scattered across the relevant precedent. So what this means is that you have to read and analyze the precedent together as a whole, not as separate isolated cases. So keep that in mind. So step two is, once you found the rule, you need to create a list of the rule's components. Whether those components are mandatory elements, each of which the party stating the claim must satisfy, or they could be discretionary factors that the court is going to weigh as guideposts in reaching its decision. So you're gonna identify the rule's components and create a list of them. And then step three is to determine which of the rule components create issues, because not all of the components of the rule are going to be disputed by the parties. Those will be givens that will not require extensive discussion in your brief. Of more pressing concern are the rules components that both parties will dispute, because these disputed components are the issues that we require in-depth argument, where you're going to have to go into depth in talking about the law and how the precedent illustrates that law, and then how the court should apply that law to your client's case. So issue identification is critical. Step four. We're still focusing on large-scale structure here, in other words, the overall structure of your argument. So, once you've identified the issues from your list of rule components, you need to then consider the order in which you're going to argue those issues. It's important that you always first examine those issues to see if there is a threshold issue. In other words, is there an issue that you have to tackle before the other issues. For example, there might be an element of the main rule that you have to address first before you get to the other elements. It's a triggering element, so to speak. If you have a threshold issue, you must argue that issue first in your argument, even if it's not your strongest issue in your argument. However, if there's no threshold issue, then best practices in terms of persuasion dictate that you start your argument with your strongest issue. In other words, the issue that you feel stands a decent chance of being resolved in your client's favor. Leading with your strongest issue is important because it shines the spotlight on the issue that the court is probably going to consider most important. And as we'll focus on in some of these videos, judges really want to know only what's important. All right, so once you've listed your issues in a persuasive order, ideally, then you need to consider how to introduce those issues in your argument to the judges. How do you do that? Well, you're going to sketch out a roadmap to do that. A good roadmap, you may recall, is going to contain two critical components. First, it's going to state the main rule of law that the judges must use to resolve the appeal, and in other words, to resolve the main issue. And second, a good roadmap is going to give the judges a preview of where the rest of your argument is going. In other words, a summary of what you're going to say in your argument for the issues. Okay, that gives the judges a clear indication of your argument's direction. Again, that's important because the judges want you to get to the important information as quickly as you can. They want to know where you're going with your argument. Last step. Now we're focusing on planning your argument's small-scale organization. In other words, how you're going to organize your argument of each individual issue. You're going to use the CREAC format to do this. Now, I'm not going to belabor the CREAC format again. We've covered this multiple times in the fall semester and again at the outset of the spring semester. So you ought to have a good grasp on what CREAC is. But I do want to summarize CREAC in one way. I think the simplest way you can think about CREAC is it's really a two-step process, and it's a process that the judges expect you to follow. Step one is describing the law. Okay, tell the judges what the law is for this issue. And second step, apply the law to your client's case. Okay, tell the judge how the law and your client's facts intersect to dictate a conclusion that is resolved for your client. Okay, so that's a quick rundown of putting together your oral argument. Thanks for your attention and take care.